Dear friends, we are going with the topic of Civil Procedure Code for the Munisiff Magistrate examination. It is the second part of the video done by me. By virtue of section 2 clause 2 subclause 2 of the Civil Procedure Code decree means so 2 subclause 2 decree means a formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the right of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint. It shall deemed to include the rejection of a plaint and determination of any question within section 144, but shall not include any adjudication from which appeal is as an appeal from an order. So the answer is C. Formal expression of an adjudication but shall not include any adjudication from which an appeal is as an appeal from an order. So the section 2 clause 2, section 2 subclause 2 of the Civil Procedure Code says that decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the right of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. That means decree means a formal expression of an adjudication. Adjudication means the judicial decision. The formal expression of a judicial decision which is, so far as regards the court expressing it, it is an expression of a court. Decree is the adjudication and the expression of a court. It conclusively determines the right of the parties. It is an adjudication, it is an expression, it conclusively determines the right of the parties. The right of the parties is conclusively determined by the decree. With regard to all or any of the matters in controversy. Matters in controversy means issues. All issues are discussed in the decree, or some issues are discussed in the decree. Matters conclusively determine the right of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. A decree can be preliminary decree or a final decree. Then it shall be deemed to include the rejection of a plaint. The rejection of a plaint is also a deemed decree. Deemed to include the rejection of a plaint and determination of any question within section 144 of CPC. The decree is either question related to section 144 of CPC but shall not include, decree not include any adjudication from which The appeal lies as an appeal from which an order. If there is an appeal from an order, it is not a decree. Any order of dismissal of default. Dismissal of default is not a decree. A decree is a preliminary decree when further proceedings have to be taken before the suit can be completely disposed of. The decree is said to be preliminary. The suit is not completely disposed of, and the proceeding is pending. It is final. The decree is final when such adjudication completely dispose of the suit. It may be preliminary, partly preliminary, or partly final. It may be partly preliminary or partly final. So the answer in the question number 21, by virtue of section 2 subclause 2 of the Code of Civil Procedure, decree means a formal expression of an adjudication, but shall not include any adjudication from which an appeal lies as an appeal from an order. Section 20, question number 22. A decree holder is a person in whose favor a decree has been passed or an order capable of execution has been made. The definition is provided in the Code of Civil Procedure, section 2 subclause 3 of the Code of Civil Procedure. The decree holder means, section 2 subclause 3 says that a decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. The same is produced here, so the answer is 2 subclause 3. Question 23. Which among the following is a correct regarding the decree holder? There are two things are correct. The term is not confined to the plaintiff. He need not be a party to the suit. Decree holder means need not be a party to the suit. The term is not confined to the plaintiff. Decree holder എന്ന് പറഞ്ഞാൽ plaintiff ആകണമെന്നില്ല. അയാൾ സ്യൂട്ടിലെ പാർട്ടി ആകണമെന്നും ഇല്ല. Question number 24. Question number 24. As per the provision of the code, after institution of suit, the plaintiff may withdraw at any time. As per the provision of the code, after institution of suit, the plaintiff may withdraw it at any time. പ്ലെയിൻറ്റിഫിന് ഏത് സമയം വേണമെങ്കിലും സ്യൂട്ട് പിൻവലിക്കാവുന്നതാണ്. നെക്സ്റ്റ്, എ ഫോറിൻ കോർട്ട് ഈസ് ഡിഫൈൻ ഇൻ CPC. ഫോറിൻ കോടതിയെ CPC യിൽ ഡിഫൈൻ ചെയ്യുന്നത് എങ്ങനെയാണ്? സെക്ഷൻ 2 subclause 5 of Civil Procedure Code define foreign court as the foreign court means a court situated outside India. Foreign court means a court situated outside India and not established under the authority of the government of India. Section 2 subclause 5 defines the court situated outside India. Foreign court means the court situated outside India and not established or continued by the authority of the government of India. The court situated outside India and not established or continued under the authority of the government of India is called foreign court. Section 26, the question number 26. According to section 2 clause 6 of the Civil Procedure Code, A foreign judgment means the judgment of a foreign court. The foreign judgment means judgment of a foreign court. Section 2 clause 6 says that foreign judgment means the judgment of a foreign court. Section 20, the question 27. 2 clause 9. According to section 2 clause 9, the judgment is defined as statement of grounds of an order or a decree. The judgment of grounds of an order or a decree is called section 2 clause 9. Judgment means the statement given by a judge. The statement given by a judge on the ground of decree or order. ഡിക്രിയുടെയോ ഓർഡറിൻ്റെയോ ഗ്രൗണ്ടിൽ കൊടുക്കുന്ന സ്റ്റേറ്റ്മെൻറ്റിനെയാണ് ജഡ്ജ്മെൻ്റ് എന്ന് പറയുന്നത്. സെക്ഷൻ 2 clause 9 ജഡ്ജ്മെൻറ്റ് ഡിഫൈൻഡ് ആസ് ദ സ്റ്റേറ്റ്മെൻറ്റ് ഓഫ് ഗ്രൗണ്ട്സ് ഓഫ് ആൻ ഓർഡർ ഓർ എ ഡിക്രി. Section 2 clause 9 defined judgment means the statement given by the judge on the ground of a decree or order. ഡിക്രിയുടെ ഗ്രൗണ്ടിലോ ഓർഡറിൻ്റെ ഗ്രൗണ്ടിലോ പറയുന്ന സ്റ്റേറ്റ്മെൻറ്റിനെയാണ് ഡിക്രി എന്ന് ജഡ്ജ്മെൻ്റ് എന്ന് പറയുന്നത്. ജഡ്ജ്മെൻ്റ് ഈസ് എ സ്റ്റേറ്റ്മെൻറ്റ്. Judgment is a statement given by the judge on the grounds of a decree or order. അടുത്തത്, as per the code of a judgment contains, ഒരു കോഡിൻ്റെ അടിസ്ഥാനത്തിൽ ജഡ്ജ്മെൻറ്റ് കണ്ടെയ്ൻസ് ഡാസ് the decisions on the point for determination and the reason thereof. Decision on the point for determination and reason thereof, it is included in the judgment. The points for determination is included in the judgment. The concise statement of the case is included in the judgment. Judgment contains mainly 3 parts. 1. Decision on the point for determinations and reason thereof. 2. The points for determination. 3. The concise statement of a case. So, these 3 points are included in the judgment. Next, question 29. A written statement should be filed within dash days from the date of the service of summons. From 30 days of the date of the service of summons, the written statement should be filed within dash days from the date of the service of summons, within 30 days from the date of the service of summons. In a plaint, dash are not necessary to be entered. Status of the plaint shall not necessary to be entered. In a plaint, name of the court and relief should be entered. In a plaint, the cause of action should be entered. In a plaint, names of parties and their address should be entered. In a plaint, dash are not necessary to be entered. The status of the plaintiff necessary to be entered. When the plaintiff is in the doubt as to the who should be made liable for getting his relief, who among the following can be made a defendant? All person who appears to the plaintiff to be interested in the suit, property, or claim or denial against the relief demanded. What is the question? When the plaintiff is doubt, plaintiff has a doubt Which doubt? As to whom should be made liable to getting the relief? To against to whom the prayer is set to sought for a relief? Who among the following can be made a defendant? To whom the plaintiff should be set as a defendant? So the answer is that all person who appears to the plaintiff to be interested in the suit property or claim or a denial against the relief demanded is called, it can be included in the defendant side or relief side. Question 32. A judgment, decree or order may be amended when there is a dash. There is a clerical or accidental slip or omission. A judgment or decree may be amended when there is a clerical or accidental slip or omission. Question number 33. Who may be joined as a plaintiff? In the suit where a person wants to partition of the joint family property. Who may be joined as a plaintiff in a suit where the person wants partition of a joint family property. All the members of a joint family, including all female heirs or co-sharers, who may be joined as a plaintiff in a suit whether the person wants to partition of a joint family property. There is a cause of action to partition a joint family property. Who can be make the plaintiff or defendant? That is the question. All the members of the joint family, including the female heirs or co-sharers. The co-sharers can become the plaintiff. The joint family members, the sharers can become the plaintiff, including female heirs can become the plaintiff. Next question, 34. According to section 2 subclause 11, a legal representative is a person. Who is a legal representative? Legal representative is a person in law represent the estate of the deceased. In law, he expressed the representatives of the deceased is called legal representative. 35. The present percentage of money is to be deposited by the auction purchaser. Dash percent of the money is deposited by the auction purchaser for removable property on declaring a person to be purchaser. 25%. 25% of the money is to be deposited by the auction purchaser of immovable property on declaring a person to be purchaser. 25%. As per section 2 clause 12 of the code, means profit. Hold it up. Means profit means, what is a mean profit? Mean profit means, a profit means those profit which in person in the wrongful possession or such property. Means profit means the property means profit of a property means those profit which the cost person in the wrongful possession. That person is in wrongful possession. Possession of such property actually received or might with ordinary diligence have received therefrom. A person in a wrongful possession and he is earning some goods or service or profit from that property, therefrom together with interest on such profit, with interest or without interest of that property, but shall not include the profit due to the improvement. The improvement made, received, and shall not become the improvement. made by the person in wrongful possession shall not become the improvement in the wrongful possession. So the answer is B. Those profit which those profit which the person in wrongful possession or such a property actually received or might have been received together with interest is called a means profit.